Good day, liberators. I must apologize that I haven't put out a video recently, and as you are well aware, we're extremely busy, and the moment when I make a video, it really takes me a long time to edit it, and so I need to weigh my options, whether it's I must make a video to inform you or do the work actually. And we, as Liberty Fighters Network, is the only organization which is still standing from the beginning, 2020, when the COVID-19 lockdown started, up till today. A lot of organizations which have started out then have faded away. Almost all, actually all of them who started out. And some of them, some other organizations have started out only recently or within the next past year or two. But from all the organizations who have been literally fighting in court the COVID-19 narrative. And I must be careful to say narrative, and because that is a narrative and understanding that there was a COVID-19 pandemic. We are just simply saying that we're providing you with information that's not out there in the mainstream media of the work that we are actually doing. And I'm going to show you the proof of what I'm going to say. And then you must make an informed decision. And specifically, this is about the COVID-19 vaccines. So I'm not telling you that you have to, you should not be vaccinated. I'm just giving you additional information that when you're making a decision whether you want to get vaccinated or not, whether you going to get vaccinated under such a scenario, yes or no. So let me just start off with that. It's not out there that, unfortunately, our court case against the South African Health Products Regulatory Authority had been undermined. It had been blacked out. So the mainstream media has up till date never reported on it. But I'm going to show you here that on the in beginning of June, 3rd of June 2022 already, Liberty Fighters Network has lodged an application against the South African Health Products Regulatory Authority, SAHPRA. So I'm just going to refer to them as SAHPRA, to that all the decisions relating to the COVID-19 vaccines, which were registered in terms of Section 15 of the Medicines and Related Substances Act of 1965, are reviewed, declared unconstitutional and invalid, and set aside. So we were going after all the vaccines, COVID-19 vaccines, and not just one or two, as some other organizations are doing. So we've decided that it's all or nothing. Because at the end of the day, that we were not specifically going after the science. We were going after the processes that were followed. We just felt that we are not the medical and scientist experts. So we can go and check whether the processes that were followed were correct. And by doing so, if the processes were not followed correctly, then we will get the registration, the decision to register those vaccines to be set aside. So we knew from the very beginning that, science is a very, very interesting expertise. When you ask a question, a scientific question, to two scientists, you will most probably get three or more answers. So it's always who's in which group you are that is going to have their opinion about a certain aspect of the vaccines, in this case, accepted or not. And unfortunately, there is this narrative that COVID-19 vaccines are safe. It's definitely working. And so unfortunately, the views of those who do not agree with that narrative, they are the ones who are then later on seen as the so-called conspiracy theorists. And that is exactly what I want to talk to you about. People, we must be careful. If we are going in line to challenge the whole COVID-19 narrative out there, we must be careful that there are not information put on the road we are traveling that sounds very believable because it's very comfortable for us to accept. And then we just take it and we accept it as the truth. And then later on, it comes out that, no, it's not correct. Because those who have put it there were the ones who are pro-COVID-19 vaccines. And then, unfortunately, you have fallen into that trap. And why I'm saying this is that Last year, December, I've quickly came online on a Zoom conference call with a group of so-called experts, and people who are fighting against the COVID-19 vaccines, etc., etc. And when I told them that we are of the opinion that the COVID-19 vaccines in South Africa were merely saline solution and could never have rendered the negative effects that people are claiming they are, I was immediately questioned and said, but no, people thought that I was suddenly turning against the fight of exposing the truth about the COVID-19 narrative. But the people misunderstood me. And why I said so, I'm going to show you, and in our court documents, in this case. And remember that our case has not received any media exposure up till today. Notwithstanding that we were the first ones launching a challenge against the registration of the COVID-19 vaccines. About 6 months thereafter, suddenly the media started to report about the application lodged by the Freedom Alliance of South Africa, FASA. And I will get in another video about FASA and our initial objections to the FASA court case. But the fact remains is that suddenly that case went viral and even got international exposure. But ours went totally dead under the radar. And we were fighting this all the time. And it was not strange to me when someone in that group that I was talking to on the Zoom conference call, that they did not understand me because they obviously did not follow. There wasn't enough information about our court case. But let me just show you why I have said so. In terms of the actual registration, and this is in court documents that this was exposed. Now, here is this is a document coming from from SAHPRA itself, dated the 1st of October 2022. This comes from the Health Product Register. So the Health Product Register is the register keeping track of all the registered health products in South Africa. So what this says, for example, when you take the Johnson & Johnson vaccine, the Janssen Pharmaceutica, you will see here that Johnson COVID-19 vaccine, at ingredients, this ingredient is none. So that implies that according to their own record, there was no ingredient. So it was the neutral placebo that was registered, namely the saline solution, the salt solution. Let me go further. When we go down and we do the Pfizer, Comirnaty, there again, none. Okay, so now there's already two, which ingredient says that it's none, meaning that it's a placebo that was registered saline salt solution. Let us continue. The LHC Pharmaceuticals COVID-19 vaccine, LHC, again, ingredients none. The third one. Then the fourth one, Coronavac by Curanto Pharma, again, it's none. The fourth one. And then, yeah, those were the four that were actually registered. Okay. Now, what does this mean? They're either lying to us that the ingredients are actually something else and they've just put it up as none or saline solution, or it was indeed saline solution in there. Meaning, according to us, that if the government registered those vaccines as normal placebos and they were sent out in magnitude to the people to get vaccinated, and the way that it was so quickly done means that they knew that it was safe. Because if they were quickly doing that, and I will confirm this to show you just something else now, to do it in this way was very safe, meaning that the government knew that there was no pandemic. That is our opinion. So we are saying that the fact that the vaccines were said that they're going to to cure us from the so-called COVID-19 disease means that if they have sent out placebos, saline solution, it means that they knew that there was no threat. That's the reality. Now, let me show you something else. This is the latest health product register that I've obtained. Now, when you look at this register, you'll see that there's the 3 COVID-19 vaccines: Janssen Pharmaceutical, LHS Pharmaceuticals, MC Pharma, and Pfizer Laboratories. But 2 of them, Janssen, the Johnson & Johnson, as well as COVID-19 vaccine MC Pharma, have been cancelled. Look at that. It has been cancelled. So it means that they were registered and later on their registration has been cancelled. Meaning that at some point in time they have not adhered to the conditions and terms and conditions set by SAHPRA. And we want to know what conditions they have not met. Because in our case, and I will show you that as well, we have received a record that is fully redacted. Meaning that, I just want to show you this. There's the record. Now, when you go in this record, you will start seeing, as I go through this, for example, this one is for Sun LHC Pharmaceuticals. You will see that they've redacted a lot of information from this document, blacked out an entire part. And this goes for the Janssen. I just want to see, this is Johnson & Johnson. Redacted, blacked out. Okay. Now, they didn't want to provide us with the full record because they said that the information is privileged. The information for the pharmaceutical company is privileged. So it means that the SAHPRA has protected the rights of the pharmaceutical companies, but the moment when we've started to report that there's possibly new effects, side effects, people apparently dying from these vaccines, they rather want to listen to the companies and accept their word for it. What we have highlighted in our application specifically, and let me show you this, is that there's various reports, international reports, of these companies like Pfizer being found guilty of crimes, corruption mainly, and this is that report that we've showed to the court. Then we've introduced the Sinovac brought by Indonesia. There's allegations made against them, and then there's the violation tracker, current parent company, Pfizer, safety-related offences, 5.6 billion dollars of penalties, healthcare-related offences. So we've showed this to the court of each and every one of them. And so the court was also very much in line with the arguments of SAHPRA. And I will show you a court case that has happened about the vaccines, and it was never well circulated. And the problem that we are experiencing from Liberty Fighters Network side is that the authority, the precedent that has been set in that court case is a hurdle that we must now jump over. We have to conquer that, because the people who have started that process, that court case, and I will show you that, have never appealed that judgment. So it means that I am very much understanding, because Liberty Fighters Network regularly, what we are putting in our papers and what we argue never always are properly reflected in the judgment by the court. So if the court wants to side with the other party, in this case SAHPRA and the government, then obviously there's a possibility that a lot of the information that they have put in there have not been published in the judgment or reported on in the judgment itself. But then, unfortunately, the fact that they have not challenged this judgment implies that they agree with this. They could have, if they wanted to, and they're not happy with the outcome of that judgment, they could have appealed this or challenged it, set it aside, but they did not. So let me refer to that court case that's going under the radar all the time. This is the court case of COVID Care Alliance, NPC, and others versus President of the Republic and others. There's the case. I will put it in the description. COVID Care Alliance, NPC. This is a organization that has specifically only been created for this court case. Then Transformative Health Justice, NPC, also the same. And then Free the Children, Save the Nation, NPC. They all have just been lodged or created, established shortly before the lodgement of that particular case. Now, what is very much interesting about this matter is that they have used very well-known COVID-19 vaccine specialists that the opposition like us are using against the COVID-19 narrative. So people like Dr. Edeling, Herman Edeling, and I will make a video about an incident surrounding him just after this one. Now, what the court, let me take you to the judgment, and then you see the problem that court case has created. And then you will realize that we must unfortunately follow what the court says. Not what we want to accept. We can go out in private and say that these vaccines have done this and this and this, but eventually the court, the decision of the court is the one that is the just one, is the one that we have to accept as the correct one. Hence why we as Liberty Fighters Network must go out of our way to challenge what is going on in this judgment. But let me go through this judgment because many people are not aware of this case and many people is not aware of what has transpired in this case. But let me share this with you. I've mentioned this before in other videos, but it's imperative for me to go into great detail here. Now, then, yeah, the first of the practitioners' evidence relied on by the applicants is that of the deponent to the first felony affidavit. He is Dr. De Wet Oosthuizen, who conducts a private practice in Tongaat, KwaZulu-Natal. Now, Dr. Van, I know him as Van Odendaal. Oosthuizen, I beg your pardon. Now, I've met him shortly after I got to know about the FASA case, and then I've interacted with him afterwards, and he was a medical practitioner who is adamant that the vaccines are creating a lot of havoc, a lot of injuries, vaccine injuries, and he wanted to prove that, which is a very noble thing. I don't have a problem with that. But the problem is that whoever guided them through this process as a legal practitioner, a person by the name of Ricky Erasmus. You might have known about Ricky Erasmus many a time. She has been prominent in COVID-19 challenges. But I can't see why Ricky has done this. She should have known much better not to put all these experts we are relying on to prove our point of view, to put them in front of a firing squad. And that is what she did. She put them on a platter to be destroyed. And that is the problem we are now having, that we cannot go back to any one of them to say that please help us with an expert report. So that is why our case is built purely squarely on the processes that were followed. And we can't touch the effects, the science behind it, or the diagnosis of conditions that they have highlighted in their reports as experts. But when you go through this court case, and I will put it on the link on in the description. Go and read through it, and you will understand why we are sitting in a very uncomfortable position at this point in time because of this court case. Because the moment, for example, then Dr. Edeling was very much prominent, and I will go into him specifically because it links up with another video that I want to make. But the government's response. Now, this is very important, that the deponent to the government's respondent's answering affidavit was Dr. Nicholas Crisp. He is the Deputy Director General of the National Department of Health. The Director General of that department has delegated the authority of overseeing the COVID vaccination program and the procurement of strategic pharmaceuticals to Dr. Crisp. Dr. Crisp has confirmed that he is a medical doctor and a public health specialist with years of experience in health management consulting on the African continent and has attached an extensive curriculum vitae to his affidavit. Now, what he further says is that at the inception of their opposition, the government respondents and Dr. Crisp pointed out that the applicant's application had been preceded by 2 regulatory appeals and a previous interdict application. The first of the regulatory appeals was one launched by Free the Children in terms of Section 28A1. That's incorrect. That should, I believe, be 24A1 of the Medicines Act against SAHPRA. SAHPRA's decision dated 10 September 2021 authorizing the use of the vaccine known as community FASA for use for children under age 12 to 18 years of age. This appeal has not been pursued to its conclusion, and therefore an available alternative internal remedy has not been exhausted. So the third applicant in this matter has proceeded with challenging an internal appeal about the registration of the COVID-19 vaccines. And I have a problem with such a submission. I don't believe that it is just and correct for an outsider, whoever that might be, to go and appeal a registration if you have not been part and parcel of that process from the beginning. If you knew about the registration application process of it, then you should have been part of that process from the beginning, and then if it has been approved, then you can appeal. But you cannot come in on an appeal from the outside, because the appeal should only deal with the information that has been put through before it at the point of the decision. So I don't think personally, and you can differ from me, but I don't think that an internal appeal process would have been the correct process to follow. But the fact here is that the government is saying that that process has not been finalized by the time this application was lodged. So it was basically premature, and that is problematic. If that was indeed the case, as confirmed by Justice Davis, the same judge which have heard our May 2020 case, which have and he has declared the COVID-19 lockdown as unconstitutional and invalid on the 2nd of June 2020. That's the same Justice Davis. And he has highlighted this is problematic. And then it goes on. There was apparently a second appeal as well by the same company, by the same NPC. This internal remedy has also not been exhausted. So it's also not. And then there was a previous interdict application was launched by the same 3 applicants under case number 55070-2021, whereby the applicants also sought to interdict the then acting Director General from rolling out the community vaccine. That was also a case, that never got off its of the starting block. And that case, basically the reason why Dr. Crisp referred to the previous interdict application was because it contained much of the same allegations that have been made in the present application, and that alternate remedy had not been pursued but abandoned. So instead of continuing with everything that they were previously busy with, they just abandoned everything and continued with this court case. And then their heads were given on the platter to the government by having done so above others. So I'm totally disagreeing with the tactics used by Ricky Erasmus, and sadly and regrettably, it was not the first time that Ricky Erasmus came on the scene and did not do what she was supposed to do. We can vouch for that as well, that in other cases that she was supposed to assist us, and then at the end of the day she just went on her own way. But in any event, now the issue here, let's go to 81. In respect of the medico-legal report of Dr. Edeling, Dr. Crisp opined that this report had on the face of it been prepared for use by the patient who is the subject of Ms. Oosthuizen, for litigation purposes or for purposes of receiving compensation from an administrative or regulatory body. Despite this, Dr. Crisp denies that the report correctly indicated or established a causal link between the vaccine and the serious injury sustained from the administration thereof. The basis of the report contained other irrelevant allegations or opinion evidence which Dr. Edeling was not qualified to give in regard to the efficacy of the COVID-19 vaccination program. So what he basically says here is that Dr. Edeling, who is a neurosurgeon and doing medico-legal work reports, he did not display any expertise pertaining to vaccinations and how it works and operated. So it was basically just a mere opinion in another case that was basically adapted for this case that they've pursued. And then the evaluation, this is very important because in this part, the judge basically comes and looks at the entire case, and then he evaluates everything, and then he comes to his conclusion, and this is very critical. The evaluation. Now, as can be seen from the summaries and extracts from the evidence presented by the parties, the court was faced with a vast volume of documents, some referred to in passing by the applicants and some incorporated by reference only but without specification. This is an improper form of litigation. I shall attempt hereunder to distill the conclusions reached based on all of the above, including the arguments presented both in written and orally on behalf of the parties. So what the judge basically said, that he was ambushed with a vast number of information, and even the applicants, and here I blame Ricky Erasmus again as the attorney, they did not put it in such a way that it's relevant to the purpose of this application. And then let me go to number 90, paragraph 90. In respect of any of the relief which might impact on the sale, supply or distribution of vaccines by any named manufacturer, it is clear that those manufacturers have a direct and substantial interest in any such interdictory relief. To have not joined them as parties result in a fatal non-joinder. In addition to the direct consequences of the interdictory relief sought by the applicants, various allegations of an extremely serious nature have been made against certain vaccine manufacturers, and it is manifestly unfair and against all principles of audi alteram partem to not have joined those manufacturers to the application. That non-joinder had denied them the right to deal with these accusations. This also amounts to a fatal non-joinder. Now, in our case, for example, we've only cited SAHPRA, but we have served the documentation, notified all the vaccine manufacturers, and as there is changes to the case, we've constantly informed them. So they had a choice to intervene in our case or not. So, but in this case, the vaccine manufacturers have not been cited or notified at all. I don't know, it's not clear from this whether they might have been notified or the documents have been served on them. But as reported by Justice Davis, they were not. So that is a terrible derelict of duties then of the attorney in this case. Again, Ricky Erasmus. So let me go to 91. In adjudicating the factual allegations on which the applicant sought to rely for interdictory relief, which is to a large extent final in nature, those allegations must be dealt with in accordance with the tried principles encompassed by the Plaskon-Evans rule. In short, this rule provides that in applications for final interdictory relief, an applicant can only secure relief if it would be entitled thereto based on the factual versions disclosed by the respondents to such an application, together with the allegations of the applicants which had not been denied. In the present instance, each and every allegation or conclusion made by the applicants that the administration of vaccines have led and will lead to catastrophic medical consequences for a vast number of recipients have been denied on a number of levels, least of which is that the alleged expertise relied on by the applicants are of such a nature that they constitute inadmissible opinion evidence. So what this basically says is that in law, and this is what counts at the end of the day, what they have alleged with the expert witnesses in those reports does not substantiate or not substantive enough to have actually justified the relief sought. So, and in many aspects, it was actually unreliable according to the judge. They were inadmissible opinion evidence. Okay, and then 92 paragraph. The position regarding opinion evidence is that subject to certain exceptions, it is inadmissible. One of the exceptions is an opinion expressed by an expert. The reason why such an opinion would constitute admissible evidence would be when a person, by reason of his or her special knowledge and skill, is better qualified to draw inferences from certain facts or tests or analysis conducted by such a person. Knowledge or skill in this context would refer to medical and scientific qualifications and experience in dealing with matters relating to vaccinations administered to prevent the spread of a particular disease. Now, what the judge basically said here was that the experts that has been presented were not qualified enough to have given expert or considered to be experts in the field of vaccines. Our courts have identified 3 functions performed by expert witnesses. That is, these are: 1, to give evidence of facts they have observed, to provide the court with abstract or general knowledge concerning their discipline that is necessary to enable the court to understand the issues arising in litigation, and to give evidence concerning their own inferences and opinions on the case and the grounds for drawing those inferences and expressing those conclusions. Of particular importance is the fact that the opinion of an expert must be based on a correct observation and interpretation of underlying facts, and that he must assist the court in adjudicating a matter. It goes without saying that even an expert's opinion evidence should be reliable. Therefore, it is part of the function of a court in weighing up such evidence that it has to determine whether the expert expressing such opinion has the necessary qualification and experience to enable him to express reliable opinions. A general medical practitioner would, for example, not be qualified to speak authoritatively on the significance of findings or the validity of opinions expressed in specialized fields of medicine by those who are qualified in those fields and practice therein. Courts frequently have to weigh up competing expert opinions against each other. This matter is an example for such an instance. The conflicts or disputes indicated in the reports or opinions of experts generally fall in the following categories: disputes about assumed facts, differences of analysis and inferences from established facts, competing scientific theories, and accepted professional standards of conduct. In the present instance, the qualification and knowledge of the experts relied on by the applicants have seriously been placed in doubt. They appear to be either general practitioners or not suitably qualified in the specialized fields of medical science required to express opinions, the subject matter principally viruses, vaccinations, and blood analysis. In some instances, such as the founder of the first applicant, evidenced by a layperson and attorney, this is Ricky Erasmus herself, in the field of science and medicine was tendered. So she expressed her own opinion about the research that she conducted about COVID-19. That was the left hook uppercut that this application had, that their own attorney gave an opinion, expert opinion about her own research about this matter. That is highly irregular. I've never seen that in my entire life. Over the past 30 years, I've never seen this once in any case happening, that the attorney of an applicant has made an expert opinion about it. This is the first time. And then in some instances, there are also grave doubts about the factual base for the applicant's conclusions and their research methodology. Even if one were to ignore the accusations of possible bias as a result of some of the applicant's witnesses clearly aligning themselves with so-called anti-vaxxers, in inverted commas, here are abroad their opinions, if not unreliable, are not as weighty as those of the experts produced by the respondents. I therefore accept the expert opinions relied on by the respondents and reject those relied on by the applicants. There, Ricky Erasmus have put the experts that we would have relied on to take us further. She gave them their heads on a platter in this case. Very irresponsible, I need to add. Apart from the lack of proper or admissible evidence, the applicant's case for interdictory relief suffers from further deficiencies. It is stated that in order to succeed with final interdictory relief, a party must demonstrate a clear right, an act of interference with such a right, and that the party has no other remedy. I have already indicated that the applicants do not have the right to prevent others who do not share their beliefs or opinions from being vaccinated. Okay. That is what the court rightfully said. The court said that if you guys who have lodged the application don't agree with the science, then at least allow those who do agree with it the option of getting vaccinated if they really want. And something very important is also said here. Insofar as the applicants claim that they have a right to protect others, such as minors, it has not been established that the harm which the applicants aspire to prevent actually exists, and even if it may exist in rare or exceptional cases, the benefit of vaccination far outweighs that harm. There is therefore no interference which justified any protection by the applicants or by way of a court order. Section 38D of the Constitution has therefore not been satisfied. Should the applicants otherwise wish to have vaccinations deregistered and thereby prevent their use in the country, they have the alternate remedies available to them in terms of the Medicines Act, which are remedies they have not pursued or exhausted. Having regard to the nature of the relief sought, despite the initial wording thereof, it is in substance final, not interim. The applicants have therefore not satisfied the requirements for the relief sought in Part A of their notice of motion. And this is very much regrettable. And at some place, Justice Davis, I haven't read it now, but go and read this. He basically said that vaccines was never mandatory. And that's unfortunately so. Where the problem came in was that there were companies and businesses who made policies where vaccinations were made mandatory, but the act and everything involved with the regulations applicable at that point in time never made it mandatory. So it was a problem with those respective companies who made those mandatory vaccination policies. And I'm quickly going to go and read this judgment, and you will understand that what we want and what we see is not necessarily what the court is seeing or what it is supposed to do. So we must put ourselves in the position that keep our eyes on the ball. We must go out and disprove the entire COVID-19 narrative. That is what we are out to prove, to say that the procedures were not followed to have made or declared a national state of disaster in the first instance. We are saying that by the 15th of August 2020, on their own version, the lockdown would have been over, and they still kept on with it. So all these things we are still pursuing. And what is very much important is this one case of there's the other culprit, Solidarity. Solidarity, in this case, Solidarity versus Ernest Lowe. This is the case also that we must fight against, because Solidarity has also not taken this on appeal, leaving this as the authority, the precedent that has been set to allow companies and businesses to pursue mandatory vaccination policies. Although in this case there was something else that the person did. She had an option to either get vaccinated or get regularly tested. So the court basically said that the testing was not an interference with her rights. So in this case, go and read this as well. This is the other case that has set the precedent. And interestingly, I just want to show you in this case something I've never seen in this case was signed on behalf of a judge. Does it make this a judgment and a subsequent court order? I doubt it. If the judge have not signed it off and put his signature there, then someone else could never have done this, because there's no record that this judge, acting judge of the Labour Court, Makura, has actually made this judgment. But this is out there. This is the holy grail of justifying mandatory vaccination policies, and how to circumvent the Constitution and so forth to get to that point. And I just want to conclude that people, I do understand that there appears to be a lot of alleged injury sustained by the vaccinations. There's gene therapy, there's alteration of the DNA and stuff that I honestly do not always understand. But the fact remains that from the evidence presented to us, they were initially, when there was this active run in South Africa to get vaccinated. It does appear that, according to the records of SAHPRA, that those vaccines were saline solution placebos, which make us to wonder, why did they not satisfy the people of believing that they are going to get cured by these vaccines, while they were not. They were clearly not. They were so. What was administered? People would say, "Oh, but they've put in the snake poison in there." I don't know. There's so many options, and people. That is the problem that we are sitting with. Assumption is not the way to go here. We need to get the facts, and the only way in which we can get this facts is to get the full record that we are still busy pursuing. Our matter is now going on, or is on appeal, where we want the complete unredacted record to be presented to us. Once we've got that, then we can give it to all the scientists and the medical practitioners out there, and we can say, go with it. You've got the evidence that you require, and then we want to know why those two have been deregistered. What happened? So it means that everyone who got those two vaccines specifically, and they do have new effects of some sort that they believe is attributed to those vaccines, surely if you go to a proper legal practitioner, they can create and draft the papers in such a way that you might even be successful. But now I go again and say that let's get the complete record, unredacted record, so that we can put it out there for everyone who wants to do positive things with it, to run with it. And then to those who think that we've changed our ways, don't worry. We're still on your side. We're going after this in the right way, we believe. We've seen all these obstacles on our way and on our road, and we are doing something about it in the way that we believe is the correct way, to circumvent and jump over all those hurdles that have now been put on our way. So this is the fuller version of what is actually going on out there. We have to prove, we have to physically, there's very importantly, yes, that I want to say is that there's no test out there to say, to establish what vaccine you've really got and what the ingredients of that vaccine is. There's no test that's able to do that. So until we have the complete facts, we can now say for sure that yes, the vaccines have created this. But the question is, if it's not the vaccines and people have really become sick, what caused it? There's a lot of culprits that I can mention. Maybe it might be allegedly the chemtrails. It could be contaminated water or food, gene manipulated food, G5G possibly. So there's so many culprits that could have caused these new effects. And I do not rely on the vaccine tracker, where there's a website out there where you can put in your batch number and then it links up with all the others in that batch and whether there has been reports. If it's not by a reliable source, if it's not administered by a reliable source, then any information that you put into that system can give you any answer that you want. So it's not a confirmed fact that vaccines have created this havoc as people are claiming to be. I am on your side. I'm trying to get the facts so that we can go out and prove that you are not conspiracy theorists. God bless until the next day.
Liberty Fighters Network.
Liberty Fighters Network.